The House of Representatives and Senate explained. Congressional procedure, a practical guide to the legislative process in the U.S. Congress. Richard A. Ehrenberg, forward by Alan S. Fruman, thecapital.net. Chapter 2, Introduction of Legislation, Table of Sections. A. Introduction. B. Why submit legislation. C. Drafting legislation. D. Forms of legislation. E. Bills. F. Joint resolutions. G. Concurrent resolutions. H. Simple resolutions. I. Sponsorship and co-sponsorship. J. Submitting legislation. K. Introductory statements. L. Referral to committee. M. Senate Rule 14. N. Regular order. O. Legislative process flowchart. P. Review questions. A. Introduction. In Article 1, Section 1, the Constitution places the power and responsibility to legislate in the hands of Congress. The Constitution created a bicameral Congress in which neither body is able to make laws alone. The founders designed the Congress with two distinctly different chambers, and the histories of the House and Senate since 1787 have deepened those differences. At the same time, the difficulty of passing legislation and getting it to the president's desk has increased. Turning legislation into law requires steering legislation first through one chamber, then the other, and then resolving differences between them. For legislation to become law, a bill must be passed by both the Senate and the House in exactly the same form. There cannot be the slightest difference in wording. Because House members are responsible to 435 separate constituencies and senators represent 50 different states, passing legislation requires consideration and balancing of numerous interests shaped by party considerations, local issues, regional concerns, outside organizations, and other political factors. In recent Congresses, 6 to 8,000 bills were introduced in the House and 3 to 4,000 bills in the Senate. Of these bills, the Senate passes less than 3%, and the House an even lower percentage, below 2%. Overall, less than 3% of bills introduced in a Congress actually become enacted into law. See Resume of Congressional Activity on the Senate website. The process begins with the drafting and submission of bills, that is, legislative measures. B. Why submit legislation? If so little legislation filed by members of Congress passes either body, see Chapter 2A, let alone becomes law, why do members introduce so many bills? Legislation is written and submitted for a range of reasons. Some bills are written to address a problem or issue in which the member has a particular interest or expertise. The author may chair a committee or subcommittee that has legislative jurisdiction over a matter. At other times, bills may be introduced merely to raise an issue, stimulate debate, or simply set down a marker for future action. Some legislation is filed over and over for a number of years before progress or enactment occurs. Legislators may file a broad bill in the hope that a portion may be eventually Legislators may file a broad bill in the hope that a portion may eventually be incorporated into other legislation. Often, legislation is offered simply to demonstrate to constituents or interested groups that a member is committed to action on a particular matter. This gives the member the opportunity to tell constituents and others, I have filed legislation in the Senate to address that problem. Many of these bills never progress past the point of being referred to a committee. Much legislation is filed both in the Senate and the House without the slightest expectation that it will become law. That said, the introduction of legislation can have a direct effect on executive branch actions. Intense interest in a matter demonstrated by an individual member can influence decisions even if the legislation goes nowhere. The military, for example, pays close attention to what pieces of legislation members, particularly those on the Armed Services Committee in the House or the Senate, are introducing. Legislation referred to committees is, in effect, divided into three groups. Bills that have no chance of being considered by the committee, bills that are not controversial and likely to be passed easily, and major bills that will require most of the committee's time. Most bills fall into the first category and are rarely the subject of committee hearings or formal consideration. Both the Senate and the House permit the introduction of legislation by request, such as a third party request that the legislation be offered. This can be done by members of Congress whether or not they support the legislation submitted. This might be done by leadership when requested by the President, or by a committee or subcommittee chair when requested by a department or agency of the government within the jurisdiction of that particular committee. Individual members may also offer legislation requested by a constituent or an interest group. The designation by request is actually printed on the face of such legislation. This designation has no procedural effect on the consideration of that legislation. Members sometimes introduce private bills that apply to one or several specific individuals. Most commonly, private bills are related to immigration or claims against the federal government. The House lists such bills on the private calendar. The Senate does not distinguish private bills from public bills in terms of the procedure for consideration. Most private bills introduced never receive consideration on the House or Senate floor. Those that do may require subsequent introduction in more than one Congress to reach enactment. However, the fact that most private bills do not become law does not mean they are without impact. For example, the introduction of a private bill alone can freeze immigration proceedings in some circumstances. See Chapter 4, Part E. In the first days of a new Congress, hundreds of pieces of legislation are introduced. Most of these bills that were previously introduced and died at the end of a prior Congress when they were not enacted, since all legislation not otherwise disposed of dies at the end of a Congress, that is, at the end of the second session of a Congress. Legislation carries over between the sessions of a Congress if not enacted or disposed of, that is, from the first to the second session of a Congress. The 115th Congress met from January 3rd, 2017 through January 3rd, 2019, with the first session running from January 3rd, 2017 through January 3rd, 2018. See Terms and Sessions of Congress at termsofcongress.com. In most cases, for legislation to gain traction in the Congress, attract the attention of party or committee leadership, find its way to the floor of either chamber, survive, and ultimately be enacted, its sponsors must build momentum outside of Congress among the public, influential leaders of special interest groups, businesses, labor unions, sometimes academics, and other stakeholders. The media frequently plays a role in focusing attention on particular problems and emerging solutions. C. Drafting legislation. The first step in getting a law passed is drafting legislation. Anyone may write legislation, but only a representative in the House or a senator in the Senate may introduce a bill. Most bills, however, are written by members of Congress. This is done with the assistance of staff in the member's office, committee staff, and legislative counsel. A nonpartisan legislative counsel office exists in both the House and the Senate. Ledge, pronounced LEDGE, counsel, as they are called upon to draft legislation on a confidential and nonpartisan basis. The policy objectives are defined by the member through his or her staff, and often it is the legislative council who creates the legislative language to accomplish those objectives. This assistance is available to members for drafting bills, resolutions, and amendments. The Legislative Council in the Senate is appointed by the President. Pardon. The Legislative Council in the Senate is appointed by the President pro tempore. In the House, Legislative Council is appointed by the Speaker. Additional attorneys are hired by the Legislative Council in each chamber. These are career, nonpartisan positions. These attorneys specialize in particular issues, areas, and are frequently assigned to work with specific committees. Less complex bills, resolutions, and amendments are often drafted by House or Senate staff in the members' offices or by committee staff. On occasion, legislative language is drafted and offered to members by outside groups, state legislatures, federal agencies, or even the president. Part D. Forms of legislation. There are four forms of legislation, each of which has a specific purpose. Which legislation is appropriate and is used depends on that purpose. These forms of legislation are the same in both chambers. Although legislative vehicles are frequently all referred to by the media and many others as a bill, the legislative vehicle may be a bill, Chapter 2, Section E, a joint resolution, Chapter 2, Section F, a concurrent resolution, Chapter 2, Section G, or a simple resolution, Chapter 2, Section H. The Senate, in addition to legislative matters, also considers treaties, Chapter 8, Section D, and presidential, executive, and judicial nominations, Chapter 8, Section B. Section E, bills. Most legislation is drafted in the form of a bill. Bills can be narrowly drafted to address a discrete issue. Bills can also be extensive and address a multitude of issues affecting many Americans. Most bills in both chambers are referred to a committee with jurisdiction over the issue that the bill addresses. A bill passed in the same form in both chambers and signed by the President becomes law. Article 1, Section 7 of the Constitution also provides two additional ways for a bill to become law without the President's signature. If the President does not act to sign or veto a bill within 10 days, calendar days not counting Sundays, it becomes law without the President's signature unless the Congress has adjourned during that period. Referred to as the pocket veto, the second way for a bill to become law without the President's signature is if each House votes with a two-thirds majority to override the President's veto. Chapter 6, Section G. Bills are generally numbered in the order in which they are introduced, with the exception of a few that are reserved. See Chapter 2, Section J. In each chamber, with an HR designation in the House, for example, HR 1, and an S in the Senate, for example, S1. Among the purposes of bills are authorize government activities, authorization bills, see Chapter 7, Section G, appropriate funds out of the federal treasury, appropriations bills, see Chapter 7, Section H, amend the tax code, tax bills, amend existing federal laws, private bills. Section F, joint resolutions. A joint resolution is similar to a bill, although usually more narrowly specific in scope, for example, used to correct an item in existing law or to create a national day honoring grandparents. Like a bill, all joint resolutions must be passed by both chambers. If the resolution is passed in identical form and signed by the President, or is allowed to become law without his signature or is passed over his veto, it becomes law. The exceptions are joint resolutions proposing amendments to the Constitution, Article 5, which are not presented to the President for signature. See Chapter 8, Section R. Unlike bills, resolutions may contain a number of whereas clauses that detail the rationale for the resolution. Joint resolutions are also numbered in a similar fashion to bills. In the House, they are designated as HJ-Res, HJ-Res 1, for example. In the Senate, joint resolutions are assigned SJ-Res numbers, for example, SJ-Res 1. Joint resolutions, when used to propose amendments to the Constitution and passed with identical language by a two-thirds vote in each chamber, are sent to the states rather than the President. Constitutional amendments then require ratification by three-fourths of the states within the period of time prescribed within a joint resolution in order to amend the Constitution. Among the uses for joint resolutions are continuing appropriations resolution, known as a CR, see Chapter 7, Section H, Declaration of War, Chapter 7, Section N, disapproval or approval of a presidential action or recommendation, for example, under the Congressional Review Act, Chapter 7, Section M, or the War Powers Act, Chapter 7, Section N, very specific purpose, such as establishing a national holiday. Chapter 2, Section G, Concurrent Resolutions. Concurrent resolutions, in order to take force, must be adopted by both chambers with identical language. They do not go to the President and do not become law. Concurrent resolutions are best described as an expression of the will of the Congress. In fact, some concurrent resolutions express the sense of the Congress on something. The resolution states it is the sense of the Congress that, and lists one or more expressed opinions. Concurrent resolutions have been used to express Congress's views on a very broad range of matters over the years, probably most commonly in the foreign relations sphere. For example, both the House and Senate adopted a concurrent resolution in 2013 expressing the view of Congress that North Korea should respect the fundamental human rights of its citizens and dismantle its nuclear weapons program, and end its nuclear and missile proliferation. Although concurrent resolutions do not carry the force of law, they are frequently viewed as influential and important. Resolutions provide the opportunity for members to show support or opposition to a policy without the need to pass a law. Government agencies, states, and foreign governments pay attention to what the Congress is expressing on issues of importance to them. Concurrent resolutions are also used to take joint administrative actions. They are not binding except on the Congress itself, which is subject to change by a later Congress. The most prominent concurrent resolution is the Congressional Budget Resolution under the Budget and Impoundment Control Act of 1974. See Chapter 7. Under the Constitution, Article 1, Section 5, neither chamber can adjourn for more than 3 days without the approval of the other house. This approval is granted by means of a concurrent resolution, either for adjournment, sine die, Latin for without any day, or adjournments lengthier than the 3-day limit. Among the purposes for which concurrent resolutions are used are Congressional Budget Resolution, adjournments of Congress, corrections of enrolled measures, creation of joint committees, providing for a joint meeting or session of Congress, sense of Congress on some matter. Concurrent resolutions, like bills and joint resolutions, are assigned a number as they are submitted and designated as S.con.res, S.con.res 14, or H.con.res, H.con.res 14. Chapter 2, Section H, Simple Resolutions. Simple resolutions may be adopted by either the Senate or the House. They are similar to concurrent resolutions in that they do not become law. They require adoption in only one chamber and are binding only on that chamber. They are numbered sequentially and separately like bills, joint resolutions, and concurrent resolutions. They are designed as H.res in the House, H.res 14, and S.res in the Senate, S.res 14. Both the House and the Senate adopt sense of the House or sense of the Senate resolutions, respectively, to express the opinion of that body. Simple resolutions are also used in each chamber to change the rules. In the House, this requires only a simple majority vote. In the Senate, although the rules may be changed by a simple majority, ending debate on that rules change in the event of a filibuster may require a two-thirds vote of all senators voting, provided a quorum of 51 senators or more is established. This makes it extremely difficult to adopt a controversial rules change. In the House, simple resolutions reported by the Rules Committee play a crucial role and are an important tool for majority control and the Speaker's power in that chamber. For most major legislation, it is the Rules Committee that decides if and how a measure will be considered on the House floor. Before most major bills come to the House floor for consideration, many bills are considered under suspension of the rules. See Chapter 4, Section F. The Rules Committee reports a special rule in the form of a simple resolution to govern floor debate. The Rules Committee, through a special rule, determines whether any amendments are in order, and if so, how many, and sometimes which specific amendments are in order. The special rule also sets the time for debate and when the vote will occur and under what specific rules. A vote on that specific rule in the form of a simple resolution occurs on the House floor prior to the legislation itself being considered. On the extremely rare occasion, on the extremely rare occasions when a rule is defeated, it is a major embarrassment for the majority leader. See Chapter 4, Part D. Some of the uses of a simple resolution include changes to chamber rules, administration of the chamber, resolution of election contests, election or of House or Senate officers, election of committee members, sense of the House or Senate or some matter, and the House special rules from the Rules Committee. Chapter 2, Section I, Sponsorship and Co-Sponsorship. The representative or senator introducing the legislation is known as the sponsor. Other members may wish to be closely identified with the introduction of a particular bill and sign on as co-sponsors. Legislation can have numerous co-sponsors. Co-sponsors who sign on to a bill prior to its introduction are often referred to informally as original co-sponsors. This status is sometimes cited by members to indicate more involvement and may reflect a role in the actual drafting than those co-sponsors who join after a bill is introduced. Frequently, sponsors and other key proponents of legislation send a letter referred to as a Dear Colleague letter to other members explaining the purposes of the bill or resolution and seeking additional co-sponsors. This practice is more common in the House because it is an efficient way to communicate a bill's intent to a large number of House members, but it is not unusual in the Senate. However, because the Senate is a much smaller body, it is easier to seek the support of potential co sponsors directly. A bill sponsor may also encourage supportive organizations and lobbyists outside of Congress to encourage other members to co sponsor. Dear Colleague letters are also used by members to communicate with other members for many purposes beyond seeking co sponsorship. Section J. Submitting legislation. The formal submission of legislation in the House begins by a member of Congress dropping a copy of the bill or resolution signed by the sponsor into the hopper, which is an actual mahogany wooden box located on the House floor, affixed to the side of the clerk's desk on the rostrum. See view of the Speaker's dais and well of the House, and view of the Speaker's dais, floor of the House, and galleries. In the Senate, bills and resolutions are submitted by bringing a signed copy to the parliamentarian at the rostrum. The parliamentarian is seated at the front of the chamber, just below the presiding officer. Alternatively, the senator may submit the amendment by introducing the bill or resolution from the Senate floor. In the latter case, once the measure is introduced, the presiding officer will state the bill will be received and appropriately referred. See view of the Senate rostrum or presiding officer's dais. Once the bill is submitted, it is assigned a number by the bill clerk reflecting the order in which bills were submitted in that particular Congress. In the House, the number will be preceded by H.R. 56, indicating it is a House originated piece of legislation. A bill introduced in the Senate will have an S designation preceding the number, as in S56. It has become customary for the majority leadership in each chamber to reserve the first several bill numbers, generally 10, for legislation reflecting the party's major policy objectives. Similarly, the next 10 are often reserved for use by the minority leadership. Members are able to reserve particular numbers that have symbolic value. Another reason to reserve a number is to retain the number for a particular bill previously introduced in preceding Congresses to make it easier for others to recognize and remember, which may help in the effort to build momentum from one Congress to the next. Identical bills may be introduced in both chambers. Section K, Introductory Statements. In both chambers, legislation can be introduced without any accompanying statement by a bill sponsor. In the House, there is usually no statement of introduction. In the Senate, it is common for a senator to submit a statement of introduction to appear in the congressional record. On occasion, senators will deliver that statement on the Senate floor at the time the bill is introduced. Members in both chambers typically issue press releases announcing the introduction of legislation, and for significant legislation may hold news conferences or other events. Section L, Referral to Committee. In both chambers, once introduced, most bills are referred to the appropriate standing committee with jurisdiction over the subject of the legislation. Similar to an original bill, legislation passed by one chamber is messaged to the other body and is referred to a committee. Rules, principally Rule 25 in the Senate and Rule 10 in the House, and precedents have established jurisdictions for each chamber's committees. In some cases, the jurisdiction is affected by agreements made between committees. Such agreements are generally in writing in the form of a memorandum of understanding between the committees involved, and the memorandum is subsequently placed in the congressional record. However, for the Senate parliamentarian to act pursuant to any such intercommittee agreement, a unanimous consent agreement would be necessary to formalize such an agreement in the Senate. Legislative jurisdictions are vigorously defended by both Senate and House committees. Challenges are usually worked out between committee chairs and may lead to written agreements and unanimous consent agreements. On occasion, jurisdictional battles spill onto the floor. The determination of which committee a particular piece of legislation will be referred to is made by the Speaker in the House of Representatives, and in the Senate, the presiding officer makes the decisions pursuant to Senate Rule 17 and Rule 25. In both chambers, the judgment is made by the respective parliamentarian and reliably followed by the presiding officer. Most referral decisions are comparatively routine. Legislation affecting taxes, for example, is referred to the Ways and Means Committee in the House and to the Finance Committee in the Senate. A bill raising the salaries of members of the armed services would be referred to the Armed Services Committee in the chamber where the bill was introduced. In some cases, overlapping jurisdictions or the complexities of the bill itself make the committee referral decision difficult and occasionally controversial. Disputes are generally resolved informally and sometimes result in a unanimous consent agreement. The success or failure of a bill or resolution at the committee stage can depend greatly on its committee referral. Some committees might be more amenable to a particular proposal than others. Sometimes the fate of a measure can hinge on who chairs the committee. As a result, in some cases, Bills are written with the committee referral in mind, and specific language may be used to influence the referral decision. The parliamentarian may identify for sponsors the specific factors considered in order to determine jurisdiction, and the parliamentarian may assist staff in making the appropriate and best arguments to steer a bill to a specific committee. When legislation impacts matters in the jurisdiction of several committees, a bill or resolution may be referred to more than one standing committee. This occurs more commonly in the House than in the Senate, where it almost always requires unanimous consent and is therefore quite rare. In the House, multiple referrals of several types are sometimes made. One committee is designated as the lead committee by the Speaker. Committees may also receive a sequential or split referral from the Speaker. A sequential referral refers to a circumstance in which a second committee considers the measure after it is reported by the lead committee. A split referral involves designating different segments of the bill to the two committees. The Speaker may impose a time limit on committees receiving such multiple referrals. In the Senate, the parliamentarian normally determines which committee's jurisdiction predominates, and the legislation in question is referred to that committee in the name of the presiding officer. One common exception is the Intelligence Authorization Bill, which is reported by the Senate Select Committee on Intelligence each year. The Senate Armed Service Committee seeks in the Senate Armed Service Committee seeks and is granted sequential referral of this bill. This is because many of the personnel decisions and much of the funding provided for intelligence activities relate to parts of the Department of Defense. Section M of Chapter 2, Senate Rule 14. Any senator may, and the majority leader frequently does, make use of Senate Rule 14. Under the rule, any senator wanting to circumvent the normal referral of a bill or joint resolution to a standing committee can take steps that result in the legislation bypassing referral to a committee and being placed directly on the Senate calendar of business on the next legislative day. See Chapter 5. Senate Rule 14 requires that every bill or resolution submitted be read twice before being referred to committee. A third reading is required just prior to the vote on final passage of legislation. Rule 14 stipulates after the first two readings of a bill or resolution, if objection be made to further proceeding thereon, be placed on the calendar. Since such an objection may be lodged by any senator, all senators have the procedural ability to circumvent the committee referral process and have the legislation placed directly on the Senate's calendar, meaning that it is available for consideration on the Senate floor. This process takes 2 legislative days. The day on which the measure is first introduced and read twice, followed by an adjournment of the Senate and the next convening of the Senate. In the Senate, legislative days end upon adjournment of the Senate. Therefore, legislative days may take multiple calendar days. However, getting legislation to the Senate's calendar by no means assure that it will be considered on the floor. By Senate tradition and precedent, only the majority leader decides which matters will be scheduled for floor consideration. Therefore, as a practical matter, using Rule 14 as a strategy to bring a bill to the Senate floor without committee consideration is only available to the majority leader. It has been a powerful tool for the majority leader to expedite certain major legislation, to consolidate the work of several committees in one bill, or, on occasion, to avoid the referral of the bill to a particular committee where the chair might have views different from those of the leadership. As the Senate in recent years has become more polarized along party ideology, As the Senate in recent years has become more polarized along party and ideological lines, the leadership in the Senate has become more centralized. As a result, recent Congresses have seen tools like Rule 14 and other procedural rules and traditions like the filibuster holds on legislation and nominations, the feeling of the amendment or the filing of the amendment tree, see Chapter 5, Section K, the blue slip in the blue slip in the Judiciary Committee, and the reconciliation process in the Budget Act increasingly used to circumvent the normal procedure in the Senate. Again, as the Senate in recent years has become more polarized along party and ideological lines, the leadership in the Senate has become more centralized. As a result, recent Congresses have seen tools like Rule 14 and other procedural rules and traditions like the filibuster holds on legislation and nominations, the filing of the amendment tree, see Chapter 5, Part K, the blue slip in the Judiciary Committee, and the reconciliation process in the Budget Act, increasingly used to circumvent the normal procedure of the Senate. Section N. Regular Order. In both chambers, some members have spoken out against a growing trend toward use of the rules to bypass what is commonly called the regular order. Much of what is meant by members of Congress when they refer to regular order is the normal legislative process set out in this chapter and Chapter 3. Such procedures would include the referral of legislation introduced to the committees of jurisdiction, availability of proposed legislation to the public, the conduct of hearings in committee, debate and consideration of amendments and committee markups, and potentially the reporting of legislation to the House or Senate floor for debate and amendment in the respective chambers. Since the 1990s, the regular order has not been respected on some pieces of major legislation. Bills crafted in the Speaker's office or the Senate Majority Leader's office have been brought directly to the floor through the Speaker's control of the House Rules Committee or the use of Rule 14 in the Senate. The abandonment of regular order can be best illustrated with respect to the appropriations process. Congressional decisions about the expenditure of public funds, appropriations, normally require the Appropriations Committee report 12 separate appropriations bills that fund the various departments and agencies of government. The inability of Congress to pass the necessary 12 appropriations bills as required by the end of the fiscal year on September 30 to avoid the shutdown of the federal government has led to the reliance on short-term joint resolutions known as continuing resolutions or huge omnibus appropriations bills. See Chapter 7.h. Omnibus bills lump multiple appropriations measures together, sometimes with other extraneous legislation. These omnibus bills are sometimes sent directly to the House and the Senate floors and passed, frequently with only minimal time for members to review their content. If an omnibus only includes a few bills, maybe 3 or 4, it is referred to by some as a minibus. In July 2017, the late John McCain, a Republican from Arizona, in a speech which virtually all senators present on the floor urged his in a speech with virtually all senators present on the floor, urged his Senate colleagues to return to regular order. We've been spinning our wheels on too many important issues because we keep trying to find a way to win without help from across the aisle. That's an approach that's been employed by both sides, mandating legislation from the top down without any support from the other side. With all the parliamentary maneuvers that requires. Part Continuing, it should be pointed out that this popular use of the term regular order could confuse some observers of the Senate because the term does have a technical parliamentary meaning in that body. It technically refers to returning to It technically refers to returning to an amendment or measurement set aside for another amendment or measure by unanimous consent upon a call for the regular order. And the point is that the late Senator John McCain also used parliamentary procedure to delay vote, and to call upon the regular order was not a call for uh, order the way we would have it, just like days in the Senate are not days the way we have it. The regular order of the Senate is to use parliamentary procedure, which you're learning in this book here. There is a flow chart, a legislative process flow chart from thecapital.net. So you can go there, the Capitol, TheCapitol.net, and it's called legislativeprocessflowchart.com. Legislation may begin in either chamber. Similar proposals are often introduced in both chambers. Measure introduced in the House. The measure referred to committee, which holds hearings and reports measure to the House, or for important measures, special rule reported by the Rules and Committee and adopted by the House. Leadership schedules measure for floor consideration. House debates and can amend measure. House passes measure. Measure introduced in the Senate. Measure referred to the committee. Measure introduced in the Senate. Measure referred to committee which holds hearings and reports measure to the Senate. Leadership schedule measure. Leadership schedules measure for floor consideration. Senate debate. Senate debates and can amend measure. Senate passes measure. Measures must pass both the House and the Senate in identical form before being presented to the President. One chamber agrees to the other chamber's version, or each chamber appoints members to a conference committee which reconciles the difference and agrees to a conference report. House approves conference report, Senate approves conference report, or House and Senate exchange amendments to bill and reach agreement. Legislation presented to the President. President signs measure, measure becomes law. If President does not sign measure into law within 10 days, if Congress is in session, measure becomes law. If Congress is not in session, measure does not become law. Pocket veto. President vetoes measure. Measure does not become law unless both chambers override veto by 2/3 majority. The legislative process flowchart is from Congressional Procedure, Chapter 2.0, copyright by thecapital.net. The flowchart is licensed under a Creative Commons Attribution, No Derivatives 3.0 unported license. Permission beyond the scope of this license may be available. www.thecapital.net 202-678-1600, and I am not at the moment, and I don't believe I will be eligible to receive YouTube funding for this here, and I'm not eligible in general, so I believe I fall under the license. Part O, legislative process flowchart, and which is what we just read. Part P, review questions. As a member of Congress, what factors might cause you to submit legislation? What if you had no idea how to draft legislation to carry out your solution to a particular problem? Why might a private bill even be fair? What are the forms of legislation and what is the usage of each? Why might the sponsor of a bill prefer referral to one committee over another? What can the sponsor do about it? Some people argue that Senate Rule 14 has been abused in recent years. Why could frequent use of that rule to circumvent committees be considered an abuse? What is regular order and why does it matter, if it does? Why would a member write a Dear Colleague letter? Who makes the judgment as to which committee bill? Who makes the judgment as to which committee a bill will be referred? Who must pass a sense of the Congress resolution for it to take effect? Why might it be important? End of chapter 2.